The Honorable Supreme Court of the State of Nebraska is now open for the transaction of business. Draw nigh, all ye having business with this honorable court, and ye shall be heard. God save the State of Nebraska and this honorable court.
Thank you. You may be seated. Good morning to everyone. We will begin this morning with introductions from the court. I am Mike Hevican, and I am the Chief Justice, and now, by order of seniority, as to service on the court, the other members of the court will introduce themselves.
Good morning. I'm Lindsay Miller-Lerman.
William Castle, good morning.
Good morning. I'm Stephanie Stacy.
Morning, I am Jeff Funk.
Jonathan Papik, good morning.
And John Freidenberg.
Thank you, members of the court, and our bailiff this morning is Allie Stewart. And our first case of the day is Planned Parenthood of the Heartland, Inc. versus Hilgers. Each side has up to 15 minutes in this argument. Is it Mr. Siegel?
Yes, sir.
Good morning to you, and Mr. Hamilton, good morning to you. I'm presuming you two will be doing the arguing, is that correct? Very good, then, Mr. Siegel, you may approach and you may proceed.
Good morning, Mr. Chief Justice, and may it please the court. Matthew Siegel for the appellants. With me at council table are Rose Godinez and Shinga Hong. I've asked the bailiff for 3 minutes in rebuttal time. The core question in this case is whether LB 574, which started as a restriction on gender-affirming care and came to include an abortion ban, violates a constitutional provision that plainly says no bill shall contain more than one subject. For two reasons, it does. First, the constitutional text, history, and case law make clear that a legislative enactment violates the single subject rule unless, in fact, it truly contains just one subject. But LB 574, by its own terms, contains two subjects rather than simply two aspects of one subject. And that's because LB 574 sets up its two halves as with different names, different effective dates, different enforcement mechanisms, and different procedures all the way through. These two halves of LB 574 do not implement or work with each other. In fact, aside from their inclusion in this same bill, they are strangers to each other. Second,
Doesn't Section 8 of the bill apply to both?
it is true that that one section imposes the same kinds of one of the same sets of consequences, Your Honor. But in terms of implementation, the mere fact that the law acts upon these two halves of the bill in one way that is the same in one instance does not mean that they implement or work together to accomplish a shared objective. And the second
Have
point,
we ever said, for example, that implementation on a different date makes a difference as to the single subject rule?
Your Honor, there is probably not a case in which this court has ever said that there is one thing that by itself causes a single subject rule violation. What
is the rule?
The rule is to first look at whether there is one, what the main subject, what the core purpose is, and to do so at a meaningful level.
Are those the same thing? You said purpose and you said subject. And some of our cases talk about object. Are object and subject the same in this context, or are they referring to different ideas?
As I read the cases, Your Honor, they're the same. That the way that the court has defined subjects is to look to the core purpose at a meaningful level of generality.
The literature in the area says, well, sometimes the courts are a little casual and equate subject and object, right? That's what the law journals tend to say. But isn't it the case that here and perhaps elsewhere, these one subject provisions have changed from object to subject as a statutory matter or a constitutional
That
matter?
may well be true, Your Honor, but the key takeaway from all of that discussion is that to assess what is the subject for purposes of the text, and of course the text of the Constitution uses the word subject, it's important to understand what the bill is trying to accomplish, what its aim is, and that's why the literature also says things like purpose and object. And here, in addition to...
But couldn't a bill pertain to one subject and be motivated by different purposes?
Not consistent with the Constitution, Your Honor. And the reason why...
So take a bill that's going to impose some kind of environmental regulation. And the purpose is we want to achieve some environmental goal, but we don't want to spend too much to do it. It's a balancing of purposes. And isn't that all legislation?
Yes, Your Honor. And in that situation, if the legislature were to pass a bill that had as its true aim, as Your Honor has said, to achieve some environmental regulation, the court would look to whether the provisions of the bill are comprehensively trying to do that. But what we're dealing with in this case is not some broad rewrite of any field. It is not a broad rewrite of medical procedure field or public health and welfare. It is the stitching together of two discrete aims. And that leads me to the second point I was going to mention at the outset, which is the court's cases have been clear for more than a century that the legislature is prohibited from joining two or more bills together so that the friends of each may pass them. That's from the Kansas City and Omaha railroad case way back in 1890. But that's been true.
Is that called log rolling?
Your Honor, it creates a risk of log rolling, but there need not be proof that actual log rolling occurred in order to establish that this is an impermissible violation of the single subject.
If there were log rolling here, can you explain that to us? What logs got rolled?
I will try very much to carry that metaphor forward. The way that we can see that log rolling was at least at risk here is that to borrow a phrase from the Supreme Court of Illinois in its Wirtz decision that this court cited in Wagner, we have obviously unrelated provisions being tacked on to the bill at a later time. And so the legislature itself treated these two halves of LB 574 as separately, in separate bills, until an abortion ban failed as a standalone measure. And it was only then that, again, that one log was tacked on to the other log. Now, it is impossible to say, not just in this case, but in most cases, what would have happened exactly if the legislature had maintained the separation between these two halves of LB 574. But that's why the single subject rule exists. It's not for the court to have to conjure up some alternate reality in which we can assess what would have happened. It is for the legislature to go back to the drawing board.
What do you think are the subjects or subjects at hand?
So since the bill started out as a restriction on gender-affirming care, that would be the most natural subject to mention. But it could equally be said that the bill came to have the subject of banning abortion. But
what did the legislature say the subject was?
Well, the legislature is not clear on that point.
What was the title of the bill?
The title of the bill, Your Honor, is quite long. The defendants focus on just a few words out of that title, the mention of the phrase public health and welfare.
Related to public health and welfare?
I believe that's right, Your Honor. And the problem for the defendants is that those words predated the addition of the abortion ban to the bill. So there's never been a statement by the legislature that the abortion ban piece is part of a public health and welfare bill. To the contrary, LB 626, the initial abortion ban, didn't use that term at all.
What did the district court say the subject was, and does that make any difference?
The district court said it was a health care bill, and the reason why there are so many different hypotheses as to what a single subject bill could be is that it's very difficult to navigate to a point in which it is possible to say accurately that there's one subject, and there's not even unanimity as to what it could be, and that's because there are two. And I would go back to the court's decision in the Wagner case, which again we understand occurred under a different provision, but in that case the court held that a right to obtain cannabis for medical purposes and a property right to produce it were different subjects. And so one question for the court is, if obtaining marijuana and producing marijuana are different subjects when the people vote, how can restricting gender-affirming care and banning abortion be the same subject when senators vote?
What have we said about the differences, if any, between initiative, single subject issues, if you will, or legislative generated single subject cases?
The court says that at the final step of the analysis, the question of whether there is a sufficient connection between the two bills, that there are different tests. But the court has not said that that difference extends to the question of identifying the subject, that threshold question. And indeed, Wagner seems to indicate that there is a connection between the two tests when it comes to that first step of identifying the subject.
Sometimes we get guidance from what's going on with other courts, and the briefs, and there's a lot of them, have referred to Planned Parenthood versus Reynolds. You're familiar with that case in Iowa, perhaps?
Yes, Your Honor.
Okay. So correct me as I get that wrong, I don't live there. Okay. But as I recall, the issue, it was a one-subject bill case, and one of the aspects was waiting time to get an abortion, right? And the second aspect was when to remove life-saving equipment from a minor. Is that about right?
I believe that's right, Your Honor.
Okay.
I don't live in Iowa either, but it seems lovely.
But I think what the Iowa Supreme Court said, both of those they resulted in one subject for an analytical purposes because both were towards preserving life. Okay? So that's not my question. That's just to inform us about this one subject topic. We have our own jurisprudence. Perhaps it's slightly different. Perhaps it's not. But if this court were to decide that on the abortion side of this discussion, the object was to preserve life, but on the gender side of the discussion, it was to preserve, say, breasts and genitals, should this court conclude those are one subject?
No, Your Honor, those would be quite different subjects. And just a quick response to the Iowa case. There's a couple differences there. One is that the Iowa Constitution actually has different language than this state's Constitution. It refers to not just one subject, but anything encompassing a connection. And the Iowa Supreme Court ruled in the case that Your Honor mentioned that meant it wasn't purely a single subject rule. So that's a key difference between this state and Iowa. A second difference is this court's jurisprudence, which has been clear going back to the Van Horn case that it's not permissible to reverse engineer a single subject by just picking some category that would broadly encompass the two parts of a bill that have been stitched together. That's been true for a long time, and we can see why. If it were really permissible to do that, to say, as the district court did, that this is a health care bill, or as the defendants argue that it's a public health and welfare bill, that would mean that any bill is permissible. In fact, if we took the entire cannabis initiative that was before the court in Wagner, and if that had been appended wholesale to the gender-affirming care ban in LB 574 or to the abortion ban in LB 626, under the defendant's theory, that entire bill, abortion and cannabis, or gender-affirming care and cannabis, would have been one subject. And that's what this court's cases, unlike in Iowa, say is impermissible.
As a traditional practice, the Nebraska legislature, when it starts running out of time at the end of each session, sweeps a bunch of bills together and has a slang term, a Christmas tree bill. If this court were to adopt the position you're bringing here, does that put all those bills in jeopardy? And does it matter? Should it affect our decision-making at all?
It would not put those bills into jeopardy because of the sort of perfect storm that we have here of single subject rule of problems. Not just all the differences between the bills, but the fact that the abortion ban was added only after it failed as a standalone bill. So it wouldn't really, a narrow decision in this case would not tend to jeopardize any Christmas tree bills. But even if it did, as we say in our briefs, other courts have recognized that there can be a kind of laches kind of prohibition on challenging those bills well after they've been put into effect.
Suppose, in a hypothetical, that you had a bill that came out, it's on the floor, filibuster did not advance. And then you had two separate bills, all addressing the topics that we're talking about, that came out and were adopted on the floor together. How would you apply the single subject rule in that hypothetical?
That would certainly be a tougher case, Your Honor, than this one. What I would look to in that sort of situation is to the court's decision in Luncher, which looked at whether something was introduced. In that case, it was expending tax revenue on gambling for property tax relief and education as an attempt to smooth the passage of the bill.
So
and I would look to that in Your Honor's hypothetical.
It seems to me that your answer to my question evinces the thought that you are placing tremendous weight on the way that the legislature handled the debate and the way that they progressed through the steps, as opposed to simply looking at the content and the title of the bill. Is that a fair characterization?
I would say that the court's cases place that weight. The court's cases do. I see that I'm well into my rebuttal time. I'd be happy to come up and use the remaining time at the end. Thank you.
Thank you very much. Mr. Hamilton, good morning to you.
Good morning, Your Honor. May it please the court. This court should affirm the district court's judgment for two reasons. First, plaintiff's claim is non-justiciable under the political question doctrine. By using the term bill instead of legislative acts or statutes, the Constitution textually committed this issue to the legislature, which self-polices compliance with the rule. In addition...
Didn't that ship sail about 150 years ago?
No, Your Honor. This court recently decided the Nebraska Coalition decision, which adopted a new test for the political question doctrine. It adopted the 6 Baker against Carr factors, and this court has not decided a single subject case since that decision. And in addition, going back to the very first volume of the Nebraska reports, the McCallum decision in 1871 noted that this issue might be a non-justiciable political question, and the court has never decided the issue. But even if this court found that the case was justiciable, plaintiff's claim fails on the merits. And that's because LB 574 is consistent with the legislative single subject rule. The court's most recent decision, the Jackshaw decision, sets a 2-part test for the legislative single subject rule. The first part...
Is Jackshaw your best case?
Jackshaw... I suppose, I mean, it's the most recent case, and I think it's the most on point because of that. I think there has been some evolution in the court's doctrine, and for the last several decades, cases like Jackshaw, Blackledge, and Anderson proceed more with this 2-part test that is starting with the bill's title and looking at the subject in the title, and then considering whether every element of the bill is related to and germane to the subject in the title. And LB 574 meets that standard. There are 2 policies in LB 574, an abortion policy and a gender-altering procedures policy. Both relate to that standard. Now,
And what is that standard?
That's the question.
Yes.
Beg your pardon.
The standard, after identifying the subject in the title, is whether every element of the bill is germane to the subject in the title.
And the subject is?
The subject is public health and welfare.
What do you make of the fact that the district court found the title to be, or the subject to be something a little bit different, and does that make any difference to us?
I don't think so, Your Honor. The district court said that the subject was health care, I think it was using a shorthand for public health and welfare, and I'd note that this court has sometimes done the same thing. In Jackshaw, for example, the title was taxation and revenue, but the court simply referred to the subject as being taxation. Now, Planned Parenthood would have this court turn back to older cases that use a somewhat different test that, instead of starting with the title, starts by looking at the bill and ascertaining some overall main purpose for the statute. But I didn't hear my friend on the other side say anything that showed why the overall main purpose of the bill couldn't be regulating healthcare practitioners' use of procedures and drugs that disrupt natural biological processes for especially vulnerable populations, the preborn and minor children.
Is that the title you would give it if you were the author?
No, Your Honor. Our position is that we defer to the legislature's choice of public health and welfare, but we acknowledge that much older cases take a somewhat different approach. And so under that older approach, however, LB 574 would have passed the cases like Midwest Popcorn and Van Horn.
Would it have passed, say, Oxnard Beat?
I'm not familiar with that case, Your Honor.
That's where this court said legislation pertaining to beets and chicories, two subjects.
I don't know the context of that bill, Your Honor. I would just say that
Was the district court correct in its jurisprudence where the district court said, analytically looking at one subject, go broad if it's a statute by the legislature?
Yes, Your Honor. There is a long history of this court distinguishing between process challenges to the validity of statutes and substantive challenges to
But that's not what I'm focusing on.
Oh, I'm sorry, Your Honor.
Pardon. I'm focusing on the subject. So, should initiatives be viewed, initiatives for statutes be broad and statutes, legislature for statutes also be broad, or are there different standards when it comes to statutes initiated by the people as compared to commenced by the legislature? Is
Yes,
it the
Your Honor.
same?
No, Your Honor. Different
So if
standards.
initiative had come forward and said, we're going to have an initiative dealing with abortion and gender-affirming topics, that initiative, in your view, would be one subject or two?
I think that's two subjects, because under the ballot initiative and constitutional amendments cases, there's a different test, which is whether the limits of a proposed...
But we don't have a constitutional case here, do we? We have a statute case, don't we?
Correct.
Okay.
So that test is inapplicable. The test is
Yeah.
instead
Thank
the
you.
test from Jackshaw. Midwest Popcorn is the different test that plaintiffs argue, but I haven't heard them say...
Haven't we said somewhere that the legislature shouldn't make the subject too broad, lest you can put anything in a bill and there's nothing left to the constitutional prohibition?
Actually, Your Honor, there's case law saying the opposite, because Jackshaw and Anderson both talk about how if the act has one general object, no matter how broad that object may be, and contains no matter not germane to that broad object, the statute is constitutional under the legislative single subject rule. So cases like that put a few limits on the breadth of that subject, and I'd note that cases like Van Horn also are very flexible in that they acknowledge the possibility that a bill like this one can have multiple subjects in the title, but as long as there is one subject for the bill that fits, that is going to be enough. Likewise, Midwest Popcorn even says it is okay if the bill has incorrect information in the title. That will not prevent a court from concluding that a bill is valid.
So if, for purposes of the question, if these topics were not acceptable if a statute initiated by the people, right? What do we do with our case law, Lemon v. Gale, which says the legislature and electorate are concurrently equal in rank as sources of legislation, and provisions authorizing the initiative should be construed, blah, 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 blah. So we have case law that says analytically statutes by initiative and statutes by the legislature are kind of the same.
That's
Or
right.
are they, or where are we going, or what's the state's position?
Yes. So Luncher, however, recognizes that for single subject rule purposes, the two are different. And there are a few reasons for that. Luncher talks about how...
Which Luchner, or am I losing my place?
Yeah, I'm sorry, yes. This is the, I think it's a gambling constitutional amendment case.
Okay.
But that case explains that constitutional amendments and ballot initiatives are both harder to change than bills that become statutes through the legislative process. And in addition, there's a difference between the two, because the legislature can and does enforce the legislative single subject rule, but that doesn't work for ballot initiatives and constitutional amendments.
But is that a policy view of the whole situation, or are we sticking with the text?
It's textual. I mean, the constitutional amendment section uses different words. It talks about that the amendments must enable the electors to vote on each amendment separately. So there is a textual difference there.
When you go to Article 3, Section 2, which is the initiative, one subject stuff, that constitutional provision reads, besides initiative measures shall contain only one subject. So we're using one subject for legislatures and initiatives, right? But in the Article 3, Section 2 initiative constitutional provision, it says the constitutional limitations as to the scope and subject matter of statutes enacted by the legislature shall apply to those enacted by the initiative. Does that suggest maybe analytically they should be the same, either both broad or both strict?
I don't think so, Your Honor. I think that language is referring to the breadth of legislation and saying that substantively the initiatives can't go beyond what the legislature might be able to do. And I think the important textual difference between the initiative single subject rule and the legislative single subject rule is that one is saying initiative measures and one is bills, and bills refers to draft laws, and it's appropriate for the court to
I'm taken back to Schoolhouse Rock. So we've got bills and legislative pieces and limitations. What is this one?
Well, this is, of course, a bill, but the legislature is in a position to enforce the single subject rule on bills. For initiative measures, that's not so. This court plays a role in enforcing the single subject rule because the people cannot do that. However, this court should not reach the merits because the question is a non-justiciable political question. As I said in answering the Chief Justice's question, there are 6 independent tests that this court accepted in the Nebraska Coalition decision. Each would find a political question, and at least 4 are implicated by Planned Parenthood's case. The first is that the choice of the word bill commits this issue to the legislature.
Let me interrupt you. Does the fact that Nebraska has a unicameral legislation there or have any relevance to what we are doing here today at all?
I don't think so, Your Honor. There's one house instead of 2, but it's still a legislative process that resembles
Doesn't the fact that there's only one house mean that there are fewer checks and balances in Nebraska than in other places?
Well, there are maybe different balances within the legislative branch, but I don't see any difference in the checks and balances between the different branches. It's still the case that bills pass the legislature and are signed or vetoed by the governor, and that this court reviews the statutes and legislative acts that pass through that process. But returning to the political question doctrine, the second factor that applies to this case is the fact that this is a decision of a non-judicial kind. The court says what the law is, but it doesn't say what the overall main purpose is for an act. It doesn't say whether individual sections are germane to a bill's subject. That's a legislative process call.
But this court's allowed to review whether another branch has followed constitutional process, constitutionally established processes, isn't it?
Well, what Baker against Carr says is that this court will always be able to review cases where an official has acted in excess of constitutional authority, but process-type calls made by the political branches merit additional deference. And this court's past cases reflect that. Again, going back to the McCallum decision, the case acknowledges that this might be a political question and that special consideration is warranted when the court is weighing in on procedural issues.
There are a lot of states that have single subject or single object requirements in their constitutions. Are there any courts that have found those to present non-justiciable political questions?
I'm not aware of any that have found those to present non-justiciable political questions, but I would also say there is little authority on the other side, at least among states like this one, that use the term bill in the the single subject rule. The plaintiffs cite the Shurtleff decision from the Utah Supreme Court. That is really a standing decision, and it just says in passing, without citation to Baker against Carr or related authority, that the single subject rule does not present a political question.
Let me ask you something. It's reminiscent of the title, adequacy of title questions and the language. Is this correct that the language of LB 574 uses unborn child? Is that correct?
That sounds right.
Okay. So does the state have a position on whether or not an unborn child is a, quote, person, as person is used elsewhere in the Constitution?
We have not taken a position on that today, and we don't think that the court needs to reach that decision to apply the single subject rule, which is simply focused on whether individual portions of the bill are germane to the subject.
Is it
in the title.
relevant to whether or not this is, quote, public health or private health?
Well, I think what's significant is the legislature's judgment that it is by placing that in the title. I see that I'm out of time. We ask this court would affirm the district court's judgment. Thank you.
Thank you very much. Do we have any time for rebuttal?
49 seconds, Your Honor.
49 seconds, Mr. Siegel. We'll give you an entire minute.
Thank you, Mr. Chief Justice. What we just heard were attempts to shoot the moon. Whether it's asking the court to become the first court in the history of the United States of America to hold that the single subject rule is a political question, or whether it would be asking this court to work backwards for the first time in its history from a bill's title to determine its subject, or whether it's asking this court to work backwards from some conjured up broad category instead of working up from what the bill actually does in determining its title.
I want to ask a quick question about Section 5 in each of these bills, 626 and 574. Both of them appear to regulate healthcare professionals or physicians. How is that not a single subject?
The reason why, Your Honor, is that this court has said that it doesn't start from the broadest possible, the narrowest possible category that could arguably contain the bill. It looks to what the bills do. The legislature itself treated these subjects as separate when it set up LB 574 and LB 626, and it pushed them together only when it was constrained to do so.
So you're back to it really matters how the legislature did it.
It's not just the how, Your Honor, it is also the actual scope. I would point to page 6 of the amicus brief submitted by the two senators in this case. They say the JACSA provisions, that's the other side's best case, covered much broader ground than LB 574 does. This bill is not in fact broad. It's not in fact a broad rewrite of healthcare. These are two ships passing in the night, and what they have in common, all they have in common, is the sea. Thank you, Your Honors.
Thank you very much, counsel. That concludes arguments in Planned Parenthood of the Heartland, Inc. versus Hilgers.